Okey, Assalamualaikum ya, salam sejahtera, salam Malaysia. Jadi hari ini untuk makluman tuan-tuan dan puan-puan, hari ini sesi kami akan dilangsungkan dalam bahasa Inggeris. Sebentar lagi ya apabila saya membawa masuk tetamu jemputan iaitu Peguam Muhammad Hanif Katri Abdullah. Ya, sesi ini akan dilangsungkan dalam bahasa Inggeris tetapi saya menggalakkan tuan-tuan dan puan-puan untuk terus bersama kami sebab hari ini kita akan jelaskan secara terperinci keputusan keputusan Mahkamah Rayuan berhubung dengan kes SRC membabitkan Datuk Seri Najib Tun Razak. Ya, jadi mengapa ya sesi ini dilangsungkan dalam bahasa Inggeris? Pertamanya, keputusan mahkamah telah dibaca dalam bahasa Inggeris dan yang lebih penting ianya memudahkan pihak media ataupun koresponden dari luar negara sekiranya mereka turut ingin mengikuti atau mendapat poin-poin daripada siaran ini. Ya, so akan dilangsungkan dalam bahasa Inggeris. Tetapi jika saudara-saudari ada soalan atau tidak faham bahagian tertentu sebab ianya dibicarakan dalam bahasa Inggeris, jadi di tepi sana di live chat anda boleh meletakkan soalan anda dan jika ada soalan yang sesuai, saya akan ajukan kepada Muhammad Hanif atau saya sendiri akan cuba jawab dalam bahasa Melayu. Okey, tanpa melengahkan lagi, kita mulakan. We begin this session with Muhammad Hanif Katri Abdullah, our distinguished guest. I'm going to bring him to the stage. Yeah. So Assalamualaikum Tuan Hanif.
Waalaikumsalam, Saudara Regi, and all the viewers who are attending to the show tonight. Good evening to all.
Okay, as we are aware, today our topic is the SRC appeal, the court decision, what it means. Okay, so we want to understand the court decision. There are many interpretations out there. And I've noticed that you have conflicting information being given out, churned out by lawyers, even politicians. So today we are going to try to find out what happened during the trial, what was the decision of the judge, and what is the implication of the decision by the judge. Okay, let me kick this off by telling you that following the court decision, we know that the court decided to uphold the conviction on Najib Razak, and the court decided to uphold or maintain the hukuman, as they say in Malay, the what you call the punishment, sentencing to Najib, including the 210 million fine. Immediately after the court delivered its judgment, Najib and his lawyer, Muhammad Shafi Abdullah, had a press conference. Now, the first thing I noticed in the press conference is although Shafi'i, the lawyer, said that they respect the court decision and they have no intention to, play down the court decision, but I think they spoke too much, a hell of a lot, and I got the feeling that to some extent they were playing down the court decision, they were playing down the judge. And, not only the judge's decision, the judge himself. Am I wrong? Did Shafi'i talk too much? Did Najib talk too much? Was the press conference necessary? Yes. Silakan.
Thank you, Saudara Regi. Actually, normally in a criminal matter or in any civil matter as well, you rarely find counsel coming out in public to make comments on the decision of the court, especially when there are avenues available within the court system to finally determine your grievances or your complaints. In other words, there is still pending a federal court appeal, which is yet to be heard. In fact, at the same time when the press conference was made by Shafi and Najib, I believe the duration of the press conference was 39 minutes and 40 seconds. The appeal was filed at the same time by his office. But nevertheless, I must remind ourselves as to this, that Shafi, or rather Najib Razak, was an ex-prime minister. And the issues with regards to the charges against Najib had been discussed by all angles in all avenues, whether it's official press, formal press, or even through the normal social media. To the extent there have been statements after statements made by all necessary members of the public, and I believe in current times where there are access to internet to that extent, it is not completely wrong for a council to make a press conference. I will start with that. It's not completely wrong. Because at the end of the day, they will still have to point out what they intend to do. And in pointing out what they intend to do, which of course is the appeal to the federal court, they must also be able to point out what is the basis of the appeal. So in doing so, to me, there's nothing wrong to say that despite the fact that, of course, they must respect the Court of Appeal decision, there are these grievances which they have, there are these complaints which they have, which they will raise it in the federal court. If I remember correctly, Reggie, I find that Shafi mentioned in a jest, he mentioned that they will have about 40 grounds of appeal, which normally will be put into a document which is called the petition of appeal, which is to be filed within 10 days after the grounds of judgment are ready. And since the grounds of judgment were ready on the 8th of December itself, the day of delivery of decision, and since the appeal was filed on the same day as mentioned by Shafi, so the petition of appeal will be filed by or before the 18th of December. So the 40 grounds will appear there. But in the PC, he also mentioned that he is raising in the course of that PC, he will be highlighting, and which he did, 5 issues which he found to be of grave in nature. So the starting point is I don't find that completely wrong. But secondly, there are parts of the PC, apart from pointing out the errors, which of course counsel will argue in the federal court as well, there are certain parts which are crucified, I will use the word, or rather unnecessarily attacked beyond the grounds of being able to be accepted as a proper complaint or proper criticism to the judgment. Where, for example, there is a point with regards to the Court of Appeal using the phrase that whatever transpired was more a national embarrassment. On that part, Shafi and Najib were of the view that the judges had no business to say that. That was his complaint, his PC. To the extent that he said that it can amount to defamation, or it was defamatory, of course. There's no such thing as defamation within a court's judgment, but he was trying to make public understand that I can see his point of view, why he used the word defamation. And then he went on to say that it could be expunged. Now, expungement of a portion of a judgment is done in the federal court later on when the appeal is to be heard and when the court decides. But to say that the Court of Appeal had no business at all to say that it was a national embarrassment, I would humbly say that it is completely wrong. It was completely wrong. Because what was said by the judge, if I can go to that point, Reggie, if you don't mind, just to highlight where I find the statements made by Shafi and Najib went beyond fair comments. I find that the issue of it is not in national interest, but it's national embarrassment was made by the Court of Appeal in the context of what was raised by Najib himself. What the Court of Appeal said is that among the defenses which Najib raised in the court below, which is the High Court, and at the appeal before the Court of Appeal, is that whatever he did with regards to SRC from step 1 to the last step, A to Z, so to speak, was all in the interest of the nation. Nothing to do with him personally. That is why SRC was formed, why there were initially 2 shareholders, why he was made as a shareholder rather to the MOF, why there was a board, why there was a need for him to become a legal sorry, not a legal advisor, but advisor at American company, why they had to apply for a loan for QAP, why they had to ask for guarantee from the government towards that particular loan from QAP, and the whole transaction and the business of SRC. He claimed in his defense from whatever he raised in the trial to be for national interest. But the Court of Appeal went through one by one. That's something which you have to remember. Each and every paragraph of the 399, if I'm not wrong, paragraphs in the Court of Appeal judgment, which is enlisted in the 317 pages, it actually went through, combed through each and every point raised by Najib at the trial in the court of appeal. They did not leave any one of the defense uncommented, unanalyzed. And after going through the whole process, they said that, look, what we find is, for example, on the operation, what we find is it's completely absurd that there is a board of directors, which normally there must be a board of directors in a normal company, where they are the one who manage the company. But in SRC, all their decisions were not finalized. They sent the minutes of the board directors to a shareholder, and only after Najib minutes his agreement to the board of directors decision, only then they are implemented. That goes through the whole process of SRC. So the Court of Appeal said that is not how a company is done. A shareholder doesn't interfere with the administration of the company. So his position is not a shareholder qua MOF, not a shareholder qua PM. It's he's taking very much an interest as a shareholder. That's how the court went through the facts. And the court found that the way in which the Kuak loan was approved was in a very hasty manner, did not follow the guidelines of the government itself and the law and the regulation, where everything was put through within a within a matter of the 11th hour. Today
Yes.
it's a meeting, and today you get a direction. More
Yes.
importantly, the court said that if you look at the minutes of the board meeting which approved the Najib was sitting, chairing the cabinet meeting.
Yes, exactly.
He
Exactly.
did not declare his interest that it was an SRC matter. He did not declare his interest as a shareholder in SRC to the
Exactly.
cabinet members, and he did not even stay himself out or kept himself shut from the discussion on the loan. So that
Exactly.
is not a process in which anyone can claim is in national interest. That is why the court said that looking at the way the company was administered, I'm only looking at one point, not looking at all the other points. It's clearly a national embarrassment. If a national linked company is run in that way, it is a national embarrassment. To me, I find it nothing wrong because judges, in order to make a finding of fact or an application of law to the fact, they must stress the importance of their finding. In stressing, they are at liberty to say whether it's a national disaster, national embarrassment, or whatever other phrases they find it to be fit. Like the phrase of it's even more fairy tale than the 1001 Arabian Nights fairy tale. You know, those are statements which they have a right to say upon they make a finding. So on that basis, Reggie, coming back to your question, even though I said it is the right of the council to make the PC, but there are certain parts of the PC which went beyond what would be fair comment. Having said that, what are the consequences? To me, the case between the public prosecutor and Najib Razak involves two parties, which is the public prosecutor on one hand and Najib Razak on the other hand. So if there is anyone who wants to complain that there are parts of the judgment which may be bordering contempt of court, then it is for the public prosecutor to take the necessary action in court. They are the ones who are at liberty to make the application before the Court of Appeal, to file an application for leave to cite Najib and or Shafi for contempt if they wish to. But until unless they do that, and if they do not come up with an explanation to the public whether they are considering or not, it is the right of the public to ask the AG's chambers, do they intend to take further steps on the content of the PC? That's how I would put with regards to the issue of the PC, Reggie. Yeah?
Mhm. Mhm. I would like to highlight the fact that you talked about Najib being a national embarrassment. That was interesting. It was interesting to me because, in my point of view, I did follow thoroughly the SRC trial from start to end, and I had always encouraged my readers and viewers to make sure that they, rather than listen to bloggers and non-experts, they should listen instead to the judge, the follow the proceedings, look at the evidences, look at the testimonies, look at what the lawyers are saying, and then read the judgment before you go anywhere else. So I followed thoroughly. And not only did I come, actually, it was so interesting when the judge said national embarrassment, because though it shocked me, because that was actually something I was thinking about 2 days before the judgment. I told myself how nice it would be if the judge were to actually say that Najib is a national embarrassment, and that's precisely what happened. And let me add, in my view, it's not just a national embarrassment. Najib made a fool out of the people. Why I say that is because he was also doing propaganda through his Facebook and so on and so forth, which was actually giving people wrong perceptions over matters. Let me give you an example. He did that in his PC. When a reporter from Malaysia Kini asked, Datuk Sri, what is your comment? Okay, on the statement by the judge that you are a national embarrassment. Now, to me, Najib went off on a tangent. He didn't answer the question, because he started saying that he had brought up national assets of the country and expanded national assets from 800 million to 2 trillion. I want you to comment on this. So he said 800 billion to 2 trillion. Then he also started comparing himself with the so-called alleged forex scandal, saying that the forex scandal was he used more colossal embarrassment, more colossal national embarrassment. Now, correct me if I'm wrong. When a judge makes a decision, and I think you roughly touched on that, when a judge makes a decision in the court, it is to matters pertinent to the case, relevant to the case, material to the case, including testimonies and so on and so forth, relevant to the SRC case. The judge was not making a comparison with Forex or anything else. So when the judge said national embarrassment, like you pointed out, it is all related to matters related to the case, like KWAP and so on and so forth. So when Najib did the press conference, when he said that it cannot be a national embarrassment because you have Forex. In the first place, the SRC trial was not a comparison trial, not to compare with Forex. But more importantly, when Najib used the word more colossal embarrassment referring to the Forex, he indirectly admitted that his is also an embarrassment, only Forex is more embarrassing. Anyway, my point here is that in the press conference, Najib did himself an injustice, and he was making a fool out of the people by trying to shift the spotlight onto other things, when in fact, he didn't answer the question of the reporter. What is your view on this?
Well, first and foremost, I just have a slight correction first, Reggie.
Sure.
I wouldn't go as far as saying that the Court of Appeal found that Najib was a national embarrassment. No, I didn't mean it that way. When I read the judgment, the whole of the 317 paragraphs, what I found is the court meant the whole issue of SRC
I see.
was a national embarrassment. So that's something which we have to bear in mind. Because as you correctly pointed out, the court determines what is before the court. Najib's embarrassment or Najib's flamboyance or Najib's stupidity or foolishness was not before the court. This was about a crime. Was there a proper crime committed beyond reasonable doubt with regards to the 7 charges pertaining to the funds of SRC? So the way in which the defense of management in the interest of national interest was raised, the court found that the way it was managed, the way it was handled, the way the loans were passed, the way the loans were even given, disbursed, the guarantee were given, and the whole structure of the operations of SRC, if it is a government-linked company, which it was, it is a national embarrassment. Nothing to do with Najib being a national embarrassment. I will not go that far. That's number one. Number two is with regards to the colossal, so to speak, embarrassment of another issue like Forex or whatnot. You are right. You're absolutely right. What is before the court is, as we mentioned just now, the 7 charges of SRC. The court only determines that. If the court is to go beyond that, that would be a decision which will be attacked in the federal court. That the court compared with 1MDB, for example, or the court compared with any other companies, for example, or the court compared with any other disasters in the country, for example. If that was done by the court, that would itself be a ground of attack in the federal court, which would not be a business of the court to determine. and the court did not determine any other business. So for Najib to himself refer to what he finds to be any other national embarrassment, that is his problem. That's got nothing to do with the Court of Appeal verdict or judgment and decision. Thirdly, just to add a bit before I move on the forex part, which I think you seek me to explain there on the forex issue. Thirdly, is this: I don't think Najib wanted or could even have had fooled the people. I think the PC was where Najib was making a fool of himself.
Yes.
He was he was not able to fool the people. He was making a fool of himself by
I
making
see.
these unnecessary statements. When he made statements on national embarrassment, when he talked about forex, when he talked about all the other issues in that 39 minutes 40 second video or PC, I think he made a fool of himself. Because even until now, after so many months of trial in the High Court and the Court of Appeal, he still doesn't understand what he was facing in that matter for him to talk outside the scope, which is quite sad. For an ex-prime minister, I thought he would be matured enough to understand what was before him, what was he charged for in SRC, and what was the finding of the High Court and the decision of the Court of Appeal. And he should have addressed the issue there too. He should have known that judgments made by the Court of Appeal is with regards to SRC, nothing to do with political statements. Judges and courts have no business and are not interested in the politics of the country. Even in constitutional matters, when we go to court, for example, and say that it's with regards to emergency, for example, the ordinances and proclamations should be tabled before the parliament. That is a constitutional issue. The court, in determining a constitutional issue, will not be interested to know the politics about it. Whether the government of the day had no choice but to do it, otherwise they will lose support and whatnot. That's not the business of the government of the court. What more in a criminal case? So for Najib to take that particular tune, he is completely a fool to do so in that context. I'm referring to in that context. Now coming to RCI, actually you're absolutely right. Najib is completely wrong on the issue of RCI because first and foremost, RCI was formed on the forex on the 18th of July 2019. If we have to check the facts, and I can say this because I was the lead counsel for Tun Dr. Mahathir in the forex matter. And the RCI was completed on 30th of November when it was thereafter tabled before the parliament. There were certain recommendations made by the RCI. Of course, there's another issue where I complained that 495 pages of all the documents and issues raised by Tun was never incorporated by the Secretariat of RCI within the RCI report, and which is unfair because anybody reading the RCI report in years to come would not find those 495 pages. That's the slight issue. But what happened is the RCI was concluded on 30th of November. The election, PRU 14, was only held on the 9th of May. In other words, there were a good 5 months and 9 days between the decision before the election in which the authorities could have taken action against whoever they wanted to based on the RCI report, which in any event was not a properly prepared report, to say the least. But actions could have been taken if they were serious about it. But they did not. On the 9th of May, there was a change of government. The original person who lodged the police report on the RCI finding was a person by the name of Yusuf Ismail, who was the secretary of the RCI appointed by the king, which was nominated, as you have correctly pointed out in your police report, which was nominated by the Prime Minister, Najib Razak, at that time. He lodged the report. Some months after that,
he retracted it.
Sorry?
He himself retracted it.
Yes, he himself retracted the RCI report. Yusuf Ismail, the complainant, retracted his report. And who is this person? This person was nominated by Najib, not by Pakatan Harapan, not by any other person. At the very least, definitely not by the Prime Minister number 7.
But Najib, yeah.
sorry, just conclude
Yeah.
that. So basically, when the police then came up, Akril Sani,
Yeah.
Fuzi, the then IGP came out and said that we meaning the police, have now classified the report as NFA because the complainant has withdrawn the report,
Yeah.
the report. So
Yeah.
on that basis, for him to even go on to deem in his PC, he said that the report was withdrawn by the government, Pakatan Harapan, and it
Yes.
was NFA by government. Those are false accusation on
Yes.
fact.
Yes.
Those are falsification of facts by a previous or an ex-prime minister. I find it astounding for him to do that,
Yes.
especially when the PC had got nothing to do with forex, had
Yes.
to do with his own situation going into his final lap of the
Yes.
appeal to the federal court. So that's
Yes.
basically on the RCI. In other words, not only is irrelevant, whatever was said by Najib
Yes.
was off tangent, false, and bereft of any merit in it. Yes,
Yes. I
yes,
I
Leslie.
I
Sorry,
I
you.
I find that so interesting because I raised this. I found this statement, the false statement in Najib's Facebook a few weeks ago. The same thing. He lied. He said that Pakatan Harapan had retracted the report and classified it as NFA, and I lodged a police report. And Najib still persists on lying. It's very obvious as an ex-PM, he knows it's a lie. Yeah, thank you for clarifying that. That is very important to me. Thank you for doing that. Coming up, uh, first I want to ask you, what do we expect? Moving forward? What do we expect? What is Najib's team able to do now? Many people ask me, going to the federal court. Now that's the final. I think Mahkamah Persekutuan, right? There's a last stand that they can make. What do we expect? As far as I know, Najib might either face a panel of 5 judges or 7 judges. Okay, but can you clarify that? Is it going to be 5 judges? Is it going to be 7 judges? And is it going to be a hearing just like the Court of Appeal? Is Shafi'i going to make more submissions? Does he have to necessarily provide new evidence or so on and so forth? What do we expect moving forward?
Yeah, now first and foremost, I think all of the viewers here today, and I think they would know, but just to stress the importance, that whoever it is, in this case it's Najib Razak, but whoever the individual is, they have a right to each and every avenues of justice. And in this case, Najib Razak has a right to proceed with the final course of appeal to the federal court. That
Yes.
right cannot be deprived under the rule of law for any nation to be governed by justice, by fairness, pursuant to the supremacy of the Constitution and the rule of law. Every individual, regardless whoever it is, has a right of appeal. So that's the starting point. What can happen? Now, being a court of appeal, a final court of appeal, they are bound to accept and refer their decision based on the record already available. What is the meaning of record? Now, in the Court of Appeal, there were 112 volumes of the record from the High Court, which contained all the notes of evidence of about 75 witnesses given over 86 days in the High Court. That has been binded, had been put to the Court of Appeal. That will become the main record of appeal in the federal court. And over and above that, there will be addition to that few other things. One would definitely be the petition of appeal for the federal court, which Shafi said he'll include at least 40 other points. So the 40 points will be in the petition of appeal. Petition of appeal will be put into the record of appeal. Number two, there were written submissions which were filed by both the prosecution and defense before the Court of Appeal. They come to about few hundred pages each of them. That would be included. Number three, at the time when the appeal was heard orally over 15 days and ended on the 18th of May this year, the 15 days transcribed notes will also be added into the record of appeal. And finally, the 317 pages or 399 paragraphs of the grounds of judgment of the Court of Appeal will all be put before the federal court. So the federal court will call upon both parties to appear before it to argue whether it's a 5-member quorum, 7-member quorum, 9-member quorum, or whatever. It's for the federal court to decide. It will be determined by the Chief Justice, Ya Ahmad Arif, Tun, Tengku Maimun, Tengku Mat, depending on either their own perusal of the complexity of the matter or on the application of the prosecution or defense. If either party or both of them, they say that the complexity of the matters, if there is any, requires a bench of 7 or bench of 9, then they will write and the court will consider whether they want to have it or not. So that will be determined by the federal court itself. Any party can apply, but they will be determined by the federal court. It's up to the federal court. Minimum would be 5 normally nowadays, would be 5. So when they are called upon to argue, your other question was, would there be fresh evidence? Now, on the fresh evidence, I must make one comment. That on the 7th of December, one day before the decision on the substantive appeal was delivered, there was an application which was determined by the Court of Appeal called an application to adduce fresh evidence. Now, we did discuss this on the last week, where at the end of the day, the Court of Appeal decided that in their opinion, whatever which Najib through Shafi wanted to raise as fresh evidence on the allegations with regards to Zeti and Nick Faisal, and to call the other witnesses, do not connect directly to all the elements of the 3 different categories of the charges amounting to the 7 charges. So they were not relevant to the determination. So they dismissed the application. Now, one of the grounds of appeal before the federal court will definitely be the dismissal of the application for fresh evidence before the Court of Appeal. So that fresh evidence will be ventilated again before the federal court. Was the Court of Appeal correct in dismissing the application? Having said that, if there's something else transpiring or transpires from the 8th of December 2021 until the date when the federal court hearing is heard, for example, if there is a charge against any of the family members of Zeti, if Nick Faisal is found and brought back to Malaysia and charged in Malaysia, if Jolo, for example, is only arrested and brought back to Malaysia and no longer tried in absentia and his trial starts. Now, if this happens, then maybe we can see Najib and Shafi, of course, and his team of lawyers will jump out of their seat and make various applications to stay the federal court hearing to get all this material before the federal court. Whether the federal court, even if they do that, whether the federal court is to accept the charges against the family of Zeti, if there is any, against Nick Faisal, if there is any, or against Jolo, if it's brought here, if any, are they relevant or not is what the federal court will decide. Because my reading of the Court of Appeal judgment, and to be fair, the judgment of the High Court is very extensive. My reading of both the judgments, I find that whatever is tried to be raised on Zeti, on Nick Faisal, Jolo, and whatnot, are issues which do not determine the guiltiness of Najib or do not effect to render him not guilty. Even if Zeti is liable, even if Nick Faisal is liable, even if Jolo is liable, it doesn't mean at all that Najib is not. My reading of the judgment. So on that basis, any federal court may say that doesn't matter. Let the federal court, let the other matters proceed. Let Zeti's charge proceed if there is one. Please, by all means. I'm not suggesting there should be one. Let the investigation team finish the investigation. But it's a duty of the Aegis Chambers to then announce what is the outcome. So let everything be done. But then again, whoever is to be charged, if any, has got no direct legal bearing on the guiltiness of Najib Razak on the 7 charges. That's my humble opinion from my reading of the judgment. I hope I've answered what can happen as far as the federal court is concerned.
Yes. And I want to clarify something. Even I personally want to clarify. You said if anything new transpires from the 8th of December until the federal court convenes, these evidences can be adduced or presented or
can be applied to be adduced.
Can be applied to be adduced. All right, I get that. The question I have for you, and this is personal because I really do not know. Can an evidence that transpired before the 8th, that Shafi'i or Najib may now have realized that they should have adduced, can that also be an application be made to present that to the federal court?
Okay, when you talk about fresh evidence, it's a very relevant question, Reggie. But in answering your question, it will be answered by referring to the principles or the elements of fresh evidence. Any appeal court will only allow fresh evidence to be adduced if they meet three requirements. One is if they are relevant to the charge.
Okay.
They are relevant to the issues. Relevant meanings to the legal aspect of it, not the factual aspect, not
Okay.
the what you call it, the storytelling aspect. It is about the legal aspect. Are
Okay.
they relevant? Number two, if the evidence, the so-called fresh evidence, is accepted, will it result in favor of the person applying for the fresh evidence to be adduced? In other words, if Najib applies, will it be assisting him in the appeal? If it is going to assist him, then they will be admitted. If
Okay.
it's not going to be assisting him at all, even though it may appear to be relevant, then it is not going to be admitted. But
Okay.
more importantly, comes to answer your question. I left it number three. Normally, the legal journals will put that number one, but just to leave your question to the last, I left it to number three. It is if the evidence could not have been obtained despite due diligence before the trial. So, if Najib had the material or had the opportunity to obtain the material, yet he did not diligently use it, or he thought he doesn't want to use it at that time, that would not be a ground to allow the evidence to be adduced now. All right? So, a person who wants to adduce fresh evidence must be a person who never had the chance to receive this evidence at the time of trial or at the time of appeal before the court of appeal.
Hmm.
All right?
Then in
It's not that there is a book, there is a, or rather, just to make it, there is a Coke bottle available at that time, which may have
hmm.
contained some evidence. But I thought it's not relevant to cross-examine on it. I just left it. Now I realize it may have contained a very important poison, which was not realized by any of the experts at that time. Only now I want to bring. But the death was not caused by poison. The death was caused by a stabbing of the knife. So it's not relevant. And it was also obtainable at the time when the trial was to be begun. I hope you can see, can
Yes.
imagine.
Yes. In that case, the issue being played up by the main to our viewers, to our viewers, kepada penonton, our main issue which we are going to enter into now is the issue of what was the court decision really, what did it mean, the stay of execution and all that. But before you go into that, what you just explained tells me that the issue being played up by Shafi'i and Najib, which is the Zeti issue, okay, you hear me out here. You hear me out here. What you just said tells me that the issue being played up by Najib and Shafi, which is the Zeti issue, which Najib and Zafi claim is new evidence that they wanted to adduce, which eventually was turned down by the court, will never make it to the federal court. Kepada penonton Melayu, and I'll give my argument why, and you correct me if I'm wrong. Kepada penonton Melayu, berdasarkan hujah Peguam Muhammad Hanif, bukti baru berkenaan Zeti yang ingin dibawa oleh Syafi'i dan Najib ke mahkamah tidak akan berjaya ke mahkamah persekutuan kerana because according to the prosecutor, this evidence or these matters that Najib is raising was known to them in 2020. It was known to them, and in fact, the prosecution offered Zeti as a witness because it was known to Najib, it was known to Shafi'i that the husband of Zeti had entered a surat akuan, what they call it, a sworn testimonial, and so on and so forth. But Najib deliberately chose not to accept that or to make Zeti his witness. So according to what you are saying, Najib is going to fail in his bid to raise the Zeti issue or to bring Zeti in the evidences or whatever you have it to the federal court level. Am I right?
Not completely. I'm sorry, Ragi. I'm sorry, I
Okay.
can't agree with you on that. Saya minta
Okay.
maaf, saya tidak dapat setuju dengan saudara Ragi atas isu tersebut.
Okay.
Kerana apa tahu? Even though they offered Zeti There is a big difference in law. Offering a witness to the defense. Ada beza tawarkan saksi kepada pembelaan with calling the witness as a prosecution witness.
Okay.
Okay. Dalam jenayah, in crime, is the duty of the prosecution to prove the narrative of the events. Ia ni adalah tanggungjawab pihak pendakwa raya untuk membuktikan rentetan peristiwa yang membawa kepada kebersalahan. So, if Zeti's issue is an issue which is relevant to prove the liability or the guiltiness of Najib, it is the duty of the prosecution to raise it. It's not sufficient to say, here you go, you can call Zeti.
Okay, understood.
That's not the way.
Okay.
So I'm sorry, I cannot agree with that. Number two, I cannot agree, not because of the Surah Akan Sumpah and all that. The issue with regards to the Zeti's issue is that the finding that Zeti's family were involved with Jolo was only confirmed when the money were returned by the Singapore authorities. Upon it being returned by the family to the Singapore authorities. So this evidence was never raised by the prosecution. That is why Najib is saying is that, why didn't you tell us in 2019 that you were investigating her? Why didn't you disclose this in your duty under Section 51A? That is what Najib is saying. Dalam arti kata lain, sorry for the Malay viewers. Apa yang Najib katakan adalah, kenapakah pihak pendakwa raya tidak dedahkan bahawa ada kaitan antara keluarga Zeti dengan Jolo di atas pembayaran wang oleh keluarga Zeti kepada pemulangan wang kepada pihak kuasa Singapura yang kepada keluarga Zeti sejak 2019 tidak didedahkan kepada pihak pendakwa oleh pihak pendakwa raya kepada pihak Najib, sedangkan itu tanggungjawab pendakwaan di bawah Seksyen 51A Kanun Acara Jenayah. Itu hujah mereka. But why I'm saying it's not relevant is because whether Zeti was involved or not, whether Zeti's family was part with Jolo or not, it has got no effect to the fact that Najib is guilty.
Yes.
Apa yang saya katakan adalah, bukan sahaja isu itu boleh memberikan perhatian tidak, tetapi fakta sama ada Zeti bersalah atau tidak dengan sendirinya bersubahat dengan Jolo, atau Jolo bersubahat dengan Zeti dan mempunyai kaitan dengan SRC adalah isu bebas, berasingan daripada isu kebersalahan Najib. Dia tiada mana kata orang, if there are 4 people who are charged for murder, 1 person is not around, it doesn't mean the 3 people are not guilty for murder.
Betul.
Satu orang melarikan diri, tak bermakna tiga yang dituduh tidak boleh didapati bersalah semata-mata sebab seorang tidak dituduh lagi. Undang-undang tidak sebodoh macam itu. Law is not an art.
Satu perbandingan yang cukup baik, a very good analogy and comparison.
So please, on one part I do agree he can make application, but on the other part I'm saying he can try to make the application, but my reading of the judgment, it has no effect because it doesn't go towards the guiltiness of Najib.
Understood. Yeah? Understood.
Right.
Okay, now we come to the main part. I think this is what we are here for. The SRC court judgment decision. Okay, there are conflicting views as to what the decision was. I think you yourself have raised it. Okay, was it just a stay? Did the judge just stay the what they call it, hukuman in English? My God, my English is suffering. Sentence. Yeah. Was it just a stay of sentence, or was it a stay of sentence and the stay of conviction? Yeah. Adakah hanya hukuman ditangguhkan ataupun adakah hukuman dan juga sabitan ditangguhkan? So that is something I would appreciate if you can explain. And also tell our viewers, jelaskan kepada penonton, what are the consequences if there was a stay of conviction with regards to Najib's eligibility in the general election, and what are the consequences if there was no stay of conviction with regards to Najib's eligibility in GE15. Now, why I ask you this before I pass the floor to you is because You have lawyers, you have politicians giving all sorts of views. Some say Najib cannot contest in G15, and I think you have mentioned that he can contest in G15, provided that this or that and so on. So please explain what all this is about, what this means. Yeah, silakan.
Yeah, first and foremost, Reggie, and for the viewers, I think we must first take it into proper context. When we discuss about the issue of sentence and conviction of Najib, we have to bear in mind that Najib as a person, number two, Najib as a member of parliament of Pekan, a still sitting member of parliament in a parliament which is still ongoing, and number three, Najib's what do you call it, position in order for him to become a candidate in the future election, if any.
Okay.
Now there are three different things, and these three are affected through differently depending on whatever the positions of the law and the constitution are. I'll take the first one first. Stay of execution is only relevant with regards to stopping the sentence to become operative. In other words, the sentence of imprisonment of 12 years and paying of fine of 210 million ringgit were to have been paid and complied with on the day of the decision of the Court of Appeal.
Okay.
We forget about High Court earlier. We come straight to the Court of
Understood.
Appeal on the 8th of December. But an application for stay of execution would mean that if the court grants a stay of execution, then Najib doesn't have to go to prison and Najib doesn't have to pay the fine until the appeal is heard. And that's
Okay.
what the order was given by the Court of Appeal as reported on 8th of December.
Okay.
Now, the second part. What about his position as an MP? I have to answer this first. Position of an MP, you do not need a stay of execution. You don't even need a stay of conviction for you to remain as an MP. Under the Constitution, under Article 48, 4,
Okay.
Perkara 48, Pasal 4, when the convicted person files an appeal from the Court of Appeal to the Federal Court within the period allowed, which is 14 days, if he lodges the appeal, files the appeal in that time period, automatically his disqualification as a member of Dewan Rakyat MP for Pekan is stopped, without there being a court order.
I see.
There is no need for a stay order for him to remain as an MP.
Okay.
That's something else. In other words, assuming the court didn't give him a stay of execution, go back to High Court. Assuming there was no stay of execution, Najib went to the prison. He would still be a member of parliament if he had filed an appeal, which he did file an appeal. So he would have been a member of parliament who was in prison, who may not have been able to attend the parliamentary sittings, but he would be a member of parliament. Ini rakyat kena faham.
Okay.
Kalau tiada pengantungan hukuman sekalipun, Najib kekal menjadi wakil rakyat Pekan selagi dia memfailkan rayuan. Semasa rayuan ke Mahkamah Rayuan dan baru-baru ini pada 8 Disember, dia sudah failkan rayuan ke Mahkamah Persekutuan. Jadi kalau mahkamah tak beri perintah stay pun, kalau dia masuk penjara pun, dia masih wakil rakyat Pekan yang duduk dalam penjara.
Dan
Sebab
ini menurut penetapan Perlembagaan Persekutuan.
Ini peruntukan perkara 48 pasal 4 Perlembagaan Persekutuan.
Yeah.
Not the law, the highest law, Constitution.
Okay. Okay.
Now,
Understood.
what happened in the Court of Appeal?
Okay.
From my reading of the Court of Appeal decision on 8th of December, I read one of the respected news report that the court also granted stay of conviction. Bukan saja pengantungan hukuman, pengantungan sabitan. Not only a stay of execution, but a stay of conviction.
Okay.
I was surprised. So that is why on the same day, I issued a press statement asking the authorities to clarify, was there a stay of conviction order? And I issued a letter to the registry of the Court of Appeal as a normal advocate and solicitor, not related to the matter at all. I copied my letter to the AG's chambers as well as the Shafi and Company office address for them to know that a nobody lawyer is writing a letter to the court to inquire about their court case, so don't be offended. That's the ethics.
Okay.
So that letter has been sent to the Court of Appeal effectively by hand on Thursday night.
Okay.
Now, interestingly, it was reported by the press on the 9th as well, where the press quoted my letter to the court. And thereafter, in paragraph 4 of the Malaysia Kini report, they reported that they checked with one of the deputy public prosecutors in the prosecution team in the SRC case, DPP Tuan Ashraf, the name.
Okay.
And according to Malaysia Kini, he also confirmed that the Court of Appeal made an order for stay of execution and stay of conviction.
Does that mean Najib is no longer officially considered a criminal until his final rayuan?
I'll come to that. Okay. I'm just answering the issue about was there an order for stay of conviction or not first, before we explain what is the effect of it, what is the meaning of it.
Understood.
So as it stands now, I read it in Malaysia Kini report, and the DPP, one of the DPP, not all of them, has confirmed. Thereafter, when I made a statement to that effect, what effect it could have, then there were few lawyers and few academicians who came up with a statement of their opinion. I'm not going to venture into that. But at the end of the same Malaysia Kini report, which was reported on 11th of December, yesterday at 4:44 p.m.
Okay.
Shafi is quoted in the last few paragraphs of saying that actually they number one, he said that he applied for the stay of conviction because they don't want him to lose the seat, the Pekan seat.
Okay.
First and foremost, which means impliedly he's also agreeing there was an order.
Okay.
But the part which he says that they applied to make sure he remains an MP is not correct in Constitution. Because in Constitution, you do not need a stay of conviction or stay of execution to remain an MP of Pekan. You just lodge your appeal and that's enough. So that part of Shafi's statement to the press is incorrect.
I see.
Incorrect. I would go on record to say it's incorrect constitutionally. So what is the reason for them to ask for conviction? That should be the question. Now, this issue of stay of conviction is generally not granted. There is a provision, which allows stay of conviction. It is called Section 311 of the Criminal Procedure Code. But normally, in any application in court, you don't ask and you are not granted stay of conviction. Most of the time, you stand up and ask for stay of execution to stop the person from going into prison. That's all. But it is an exception to the rule to ask and to be granted stay of conviction. What does it mean? It simply means that stay of conviction means that the operation of the conviction is stayed. You follow?
Yes,
conviction is there, conviction is not wiped out, but the operation of the conviction, what happens because of the conviction, that is stayed.
I see.
Like, for example, go to stay of execution. Imprisonment 12 years is there, fine of 210 million is there, but the stay of execution stops the operation of the sentence. You don't have to go to the prison now, you don't have to pay 210 million now. So it doesn't wipe out the sentence. Wiping out of the sentence can only be done by the federal court later. Wiping out of the conviction can only be done by the federal court. But the operation of the non-wiped out conviction is stayed, is stopped. What it means is then it comes to 48.5. 48.5 of the Constitution, which is, can a conviction and a sentence of more than 1 year's imprisonment and 2,000 ringgit fine, does it disallow, disqualify a person from being a candidate. Reading of it, yes, because even at the end of Nazlan's decision, at that time, I believe there was no report that there was a stay of conviction given by Nazlan. And at that time, in my talks and in my statements, I made it clear that Najib remains as an MP. But if there were to be an election at that time, during Mohideen time, remember there was an issue of Mohideen losing his security and all that.
Yes,
If
yes.
there was an election, then I made it very clear that under 48.5, in my opinion, Najib cannot stand for election. Why? Because there was no report for stay of conviction then. But
Yeah.
now there is a stay of conviction. Stay of conviction means the disqualification of him to be a candidate, which disqualification is because there is a conviction of that sentence. So if that conviction is not operative because of a stay order of conviction, then in my humble opinion, that is what Najib will argue for him to ask and stand for election. Now, there are some academicians have reported or referred to some of the Indian case, Indira Gandhi case, going back to 1970, to say that no, stay of conviction doesn't stay the operation of the disqualification of being a candidate. But there have been, if you have to Google only, you don't need to even have to go to the legal journals. Even if you have to Google under stay of conviction, you will find what has been discussed under Kanun India. You'll find 19,819 definition or explanation as to stay of conviction. And in the case of 2006, in the Indian Supreme Court, between Ravikant S. Patel and Sarvabhauma S. Bagadi, decided on 14th of November 2006, the Supreme Court did agree to grant a stay of conviction so that a person is not disqualified to stand for election in the
I see.
Karnataka Legislative Assembly under the Indian Section 8 of the People's Representation Act, which
I
is the
see.
same terms as our 48.5 of the Constitution. So this is what I fear and I believe, and I'm very much concerned, is what Najib would want to do. That is why he asked and obtained a stay of conviction. More importantly, when the reason given by Shafi in the Malaysia Kini report was to stay his position as MP of Pekan is not true constitutionally. You don't need a stay of conviction to stay, to remain as MP for Pekan. You don't need. By filing an appeal is enough. So, what was the reason? Why is this important? I tell you, if tomorrow the parliament is dissolved and His Majesty Yang di-Pertuan Agong decide to have PRU 15, SPR decide to fix the nomination date, for example, on the 15th of January, just for an example, with the voting to be done on 31st of January, for example. And the federal court appeal is not fixed at all until sampai May or June next year, for example. In other words, there is going to be an election before Najib's federal court. Najib will then be found, if it to be found, at the, what do you call it, nomination center and putting in his application as the candidate. What happens for the public viewers in the polling center, in the nomination center, the only judge is the returning officer of SPR. He is the one who decides whether to accept the nomination or not to accept it. Nobody else. You cannot get a judge of High Court or a federal court judge to say, no, you cannot accept this nomination at that time. And the time is 9 in the morning until most is 11 in the morning. Not more than 2 hours. Nomination closes at 10. 10 to 11 they decide. In that 1 hour, the boss, the judge of the nomination papers is the returning officer. Nobody else. So if the returning officer interprets a stay of conviction to mean, and he understands that to mean, that Najib disqualification under 48(1)(e has become non-operative to disqualify him under 48.5. Nobody can say the returning officer was wrong to accept his nomination.
I see.
Can
Okay.
you go to court to challenge it? Yes, you can go to court to challenge it after the election petition to be filed. Too late by then.
It
Public
will
will
be.
have to vote for PRU 15, would have to vote for the constituency of Pekan. Najib's name will be on the candidate. Now, if he wins, for example, or his party becomes the government, then whether you set aside the election or not, it may not have effect anyway. So the point is this: the effect is the day of conviction may be used by Najib to allow him to argue before the returning officer that I want to stand and you have no right to reject my candidate papers because of the Court of Appeal stay of conviction. And as I referred, uh, that particular decision of the Indian Supreme Court, Ravikant Patel and Sarvabhauma Bagali, is the authority in India amongst many. Uh, Not only the
Understood.
Indira Gandhi case, which says it's not a stay, there are many which says which, yes, makes the disqualification become non-operative. Now,
Understood.
that in mind, the reason why I'm raising this issue, as I did on Wednesday, within 45 minutes from reading the decision of Malaysia Kini, I raised the issue. It's because otherwise our politicians have this bad habit. They don't have, they don't think in advance. They don't think of all possibilities which may happen. Mainly because they have too little respect to the constitution. They are not bothered about the various content of the constitution, and they leave it too late. Now, if you don't do anything about it now, by the time if that happens, I'm not saying it will happen. If that happens, it's too late to raise it then. That is why now public has to ask the AG's chambers if there was a stay of conviction which one of the AG's officers has confirmed, then should not the AG appeal against that order?
Yes. Hmm.
The question is, should they not appeal against the order? Because the same Malaysia Kini report said that when Shafi applied for stay of conviction, Sidambaram objected on the stay of conviction. So if you objected, it means that you did not agree. The court
Hmm.
was to grant the stay of conviction.
Hmm.
So if you don't agree and if there was a stay of conviction, which until now there is no official statement from the court, then you should appeal. The problem with that, Reggie, is you can't appeal as and when you like.
Hmm.
You can't wait until the election and appeal against the stay order now.
Hmm.
You have only 14 days from 8th of December to lodge an appeal against any part of the order of the Court of Appeal. So the part of the order of stay of conviction, if it's not in the interest of the people, therefore it's not in the interest of the public prosecutor, must be appealed by or before 22nd of December. That is
Understood.
why I'm saying that this should not be taken lightly.
Understood.
Constitutional
Understood.
provisions, legal provisions, please leave it to the lawyers and the academicians to sort it out. Politicians should know if you want to strategize your politics properly, then you must appreciate, must respect the constitution. And if Najib is to come and argue that the stay of conviction makes the disqualification become non-operative, then you are too late if you want to complain then. My concern is that, Reggie. Because
Hmm.
if that happens, when that happens, and if that happens, it would be easy for the politicians to jump from their seats and claim undang-undang dua darjat.
Hmm. Yes.
Why
I
will you
understood.
say it then? You have a duty to avoid that now.
Understood.
Because if that happens then, as far as I'm concerned, the returning officer, if he accepts Najib's nomination form, he's absolutely correct because there's a stay of conviction. So there is no right for you to complain 3 months down the road, 5 months down the road that there is Undang-Undang Dua Darjat, when in fact there is none. If there is
Hmm.
any Undang-Undang Dua Darjat, it's the current politicians that we have who don't want to do anything efficient and blame it later just because it may not be popular. Do what is right, even though it may not be popular.
Right. Right.
That is why
Thanks.
I had to do it, Reggie. That is why I had to raise it. I'm not raising it to give free advice to Najib. I'm sure Najib has obtained very good advice from his very good counsel and team of lawyers. But I'm saying this for the public to understand. The
Understood.
public, I sympathize with the public. Our public is not informed properly. Number one, they are not given the proper statements by the AG's chambers, and they are not given proper explanation by fellow members of the bar. So I'm raising it. If it doesn't happen, if Najib doesn't stand for election, all is well and good. No issue. But if it does, that one iota of possibility, which it may happen, requires us to insist the AG to appeal against that stay of conviction order, especially if it has now been confirmed by its officer it was true. That is already, I hope it's understood by all.
Very clear, because I think you are the only lawyer who has taken the trouble to break things down into pieces and explain every part in a way that makes complete sense. And I noticed that the other lawyers, what they are doing is they are just picking out parts of the decision by the Court of Appeal, and they are just putting it out there without any detailed explanation, just concluding it for the public. So the public is really not being educated. So the public is forced to make a decision, do we trust this lawyer or not? Whereas it's different with you, because you are taking the trouble to educate the public, and I think those who are listening have got a pretty good idea what is going on. And I appreciate you for that. Thank you.
I'm just carrying out my duty for the nation. Because if we keep on complaining that our nation is going downhill, that our nation is being corrupted at all angles, the politicians are abusing all their powers, it is the duty of all of us in our profession to take up the responsibility of explaining to the public each and every aspect
Right.
of the events in their profession. That's
Right.
all I'm doing, nothing more than that.
Right. Thank you very much. I think this session went quite well. We have already reached the limit. We have been online for 1 hour and 6 minutes.
Okay.
So shall we wrap up this session? But before I do, there is a question for me in Malay, but I read it out. Then I want to just tell this person. Okay, is Muhammad Aswad. Soalan untuk Tuan Regi, adakah UMNO sekarang sedang berpecah? Adakah Ismail Sabri tak sehaluan lagi dengan kluster mahkamah? So Muhammad Aswad, saya rasa soalan tu saya akan bincangkan dalam live peribadi saya. Ianya tidak relevan kepada topik perbincangan hari ini, tetapi saya akan menjawabnya. Rujuk kepada live saya semalam di Facebook. Saya ada membincangkan ya perpecahan yang melibatkan persengketaan yang telah muncul di antara Ismail Sabri dengan Datuk Seri Dr. Ahmad Zahid Hamidi. Jadi sila rujuk pada Facebook saya. And kepada mereka yang lain, siaran ini, this session today will be broadcast again live in Facebook tomorrow, Regi Jesse Facebook tomorrow at 10 a.m. if everything goes well. And those who have missed it here can watch it in Facebook. Kepada sesiapa yang tidak sempat menonton hari ini, anda boleh rakan-rakan anda yang tidak menonton, anda boleh memberitahu rakan anda untuk menontonnya di Facebook Regi Jesse Ritaudin, kerana live ini akan disiarkan semula pukul 10 pagi esok. So thank you Tuan Hanif for being with us. And I shall end the session, but Tuan Hanif, please don't leave. Yeah, we will discuss further backstage. So until we meet again, please share this live ya, sehingga kita berjumpa di lain siaran. Pastikan anda share live ini ramai-ramai sehingga kita berjumpa lagi. Assalamualaikum, salam sejahtera.
Salam.